So hello friends, we are starting a very important chapter, that is Court of Law. In this chapter, we'll discuss different type of courts and different types of procedure. So what is the overview of this chapter? Just see the important definitions, the types of the witness, the types of the courts, the commutation of the death sentence, judicial versus executive magistrate, inquest in India, what are the court procedure for witness, oath, different type of evidences and its punishment, examination of the witness, prosecution witness versus defense witness, leading question and hostile witness, conduct money, exception of oral testimony, where oral evidences are not needed, and a very important, dying declaration and dying deposition. So I'm starting first, like in India, now few laws are changed in 2023. In place of IPC, we got BNS, B for Bharatiya Nyay Sanhita. And friends, in this BNS, what we have, all type of crime and the punishment of crime are included in the BNS, Bharatiya Nyay Sanhita. And the total number of BNS in India are 358 sections. BNS, Bharatiya Nyay Sanhita. Now CRPC has been changed, BNSS, Bharatiya Nagrik Suraksha Sanhita. BNSS, Bharatiya Nagrik Suraksha Sanhita. And my dear friend, in this act, we have all the important procedure for criminal, procedure for court, procedure for everything that comes under BNSS. And here the number of sections are 531. Now IEA, Indian Evidence Act, has been converted in BSA, Bharatiya Sakshya Adhiniyam. All evidences and witnesses are discussed in BSA. Evidences and witnesses, the number of BSA are 170. Now, sir, we are starting with one very important word, which is more important evidence, oral or documentary. Many people are thinking, sir, documentary evidence is more valid, but you are wrong, my dear friend. Oral evidence is more valid than documentary evidence. If document is false or fake, we cannot cross-examine, but oral evidence means you are giving evidence in court. The cross-examination is very easy, because once you attend the court, you are going to be cross-examined. So if you get a question, which is more valid evidence, the answer will be oral evidence. In place of documentary, the better evidence is oral evidence. Better evidence is oral evidence. Now, sir, I am coming to a very important topic, types of witnesses. The first is common witness and the second is expert witness. Two types of witness we are coming to. Common witness is a layman witness. If you have seen some crime, or some fact, you are a common witness. Like if you have seen murder, if you have seen rape, you are a common witness. And that's why you are known as an eyewitness. One question comes in exam, it is the most common type of witness. So if you get a question, which is the commonest type of witness, it's a common witness or eyewitness. And it is based on first-hand knowledge rule. This is a very important question. This is based on first-hand knowledge rule. So if your first-hand knowledge rule is applicable here. So this is for common witness, first-hand knowledge rule. You have seen, so that is your first-hand. But sir, the second is a very important one, expert witness. And my dear friend, a very simple trick. E look like 3, so the act for expert witness is 39 BSA, 393. E look like 3. So if you get a question, what is the act for expert witness? That is 3939 BSA. Who is expert witness? Expert witness is a qualified person, and he is qualified, he is making opinion. Like I'm a doctor, I'm a qualified, I'm making many opinions, like post-mortem report, MLC. So if you are expert witness, you are giving opinion because you make some document. Example, doctor. Everyone knows that doctor makes PMR, post-mortem report, MLC, medical legal certificate document. These are the documents made by doctor. So one expert witness is doctor. Another expert witness is fingerprint expert, because fingerprint expert examine the fingerprint. The third is chemical examiner. My dear friend, chemical examiner give toxicology report. Chemical examiner gives toxicology report. Fourth is serologist, the blood report. And the fifth is firearm expert. Firearm expert who gives the range of bullet, weapon, the types of weapon, everything is given by firearm expert. So all are the expert witness. 39 BSA. Friends, this question I anticipate in exam. Volunteering of the statement is done by expert witness. What is the meaning of volunteering the statement? Sir, if you want to add some point in the statement, if you want to give some point in the statement, you can give as expert witness. Like I want to add the statement. In my statement, I want to add this point. You can add because you have knowledge. So volunteering of the statement is done by expert witness. This is a very, very important MCQ. Now, sir, expert witness may be a common witness. May be a common witness also. Expert witness may be a common witness because he can see the crime also. Expert witness can be any type of the witness, but any type of the witness cannot be expert witness. So this is also very important. Expert witness is expert witness or maybe a common witness also. Now, sir, I'm coming to few types of evidences. Now, these evidences are very important. Number one is a direct evidence. So what is direct evidence? A very simple example is, if you have seen the slide, A killed B. A killed B. And C has seen the crime. A killed B and C has seen the crime. So C is an example of direct evidence. And I already told you, C is a eyewitness. C is a eyewitness. Common witness. So direct evidence is a eyewitness or common witness. So first is direct evidence. Done, sir. The second is hearsay evidence. And observe, remember, C came out, C has seen the crime, and C told the whole story to D. C told the whole story to D. So observe, this D is a hearsay evidence. He has not seen the crime. He heard about the crime from the C. But sir, just remember, hearsay evidence is not valid in court. It's not valid in the court. So we have discussed two. One is a direct evidence. That's eyewitness. Second is another one, hearsay evidence. D is hearsay evidence. Now, sir, third, we are coming to very, very important indirect evidence. What is indirect evidence? You take inference. You take inference from the collaterals. You take inference from the collateral. You make it indirect. Inference from the collateral you are taking. Example, I am putting two examples. This is A and this is B. What is this? The number A type of indirect is corroborative. It is corroborative. So what is corroborative evidence? I am giving example. If A came out from the room with knife and E has seen A with knife. Sub E is example of corroborative evidence, indirect. A with knife, he has not seen the murder. E is a corroborative evidence. And another example is circumstantial evidence. Circumstantial evidence. What circumstances say? If A's fingerprint FP is fingerprint. If A's fingerprint was found from crime scene, A's fingerprint found from crime scene, this is a circumstantial evidence. This is a circumstantial evidence, another indirect evidence. So I have told you the many type of evidence: direct, a common witness, eyewitness, hearsay, not valid in the court. Indirect, one example is corroborative, and another example is circumstantial evidences. So these are some important questions you can get in exam, the types of evidences and types of witness. Be careful. Now, sir, I'm coming to few definition and I'm writing down number 1, number 2, number 3, number 4. Anyone who files a case, that's a plaintiff, that is from victim side. If I am filing a case, I am a plaintiff. And Dr. from the side of victim, my dear friend, from the side of victim, we have a lawyer that is a prosecution lawyer or public prosecutor, whatever you say. But the person who files a case from victim side is a plaintiff. The second, the person who is from the side of accused, that is known as defendant. Side of accused, defendant. And Dr. the lawyer here from defendant side or accused side is defense lawyer. So person who files a case is a plaintiff. Person who defends the case, that's a defendant from accused side or accused. And here you can see the lawyer is defense lawyer. Second definition is done. Now the third definition is very, very important. What is a civil case? Civil case is a case which is always between two party. Example, one party is A, another party is B. A versus B. Ram versus Shyam, that is a civil case. What are the two party case? Civil cases are divorce or property dispute case. These are civil cases. So civil case is a case between two party. But what about the criminal case? Criminal case is a case against a government. It is not between two party. I am giving example of criminal case. Example of criminal case is rape, murder, kidnapping. These are criminal case. So Dr. Saab, what we write down, it is by the government. This is a criminal case. What you write down, it is state versus accused. State versus accused. So in civil case, the two parties are mentioned. Ram versus Shyam case, if they are calling, that's a civil case. But state versus Mohanlal, state versus Ramlal, state versus anyone, the answer will be criminal case. It will be a criminal case. So just remember 4 very, very important definition. A person who files a case, plaintiff, defend the case, defendant, case between two parties, civil case, case against a government is a criminal case like rape, murder or kidnapping. So whenever you say state versus someone, that is a criminal case. Ram versus Shyam, it would be a civil case. Now, sir, I'm coming to some important definition. And also how to remember D for definition, D for though, it is 2 BNSS. D for definition, D for though, it is 2 BNSS. What are the important definition? The various type of offenses like bailable, cognizable, warrant case, summon case, these all definition comes under number 2 BNSS. D for definition, D for though, BNSS. You can remember by this trick only. Now, sir, I'll come one by one. So first I will tell you the difference between cognizable and non-cognizable offense. Cognizable offense are those offenses where police can arrest a person without warrant. So one thing is clear, these are serious crime. Police can arrest a person without warrant. Without warrant. And also you can remember by a trick MDR. These are the example of cognizable offense. So one M is very simple. It is murder. And even attempt to murder, that is also a cognizable offense. So one is M for murder. D, too important D, the one is dowry death. One is dowry death. Second is dacoity. Dacoity, the daku came, kill you and taken away the money. Dacoity. These are cognizable offense, dowry death and dacoity. R, what is R? Rape, robbery, and rash and negligent act. R, robbery, R, rape, and rash and negligent act leading death. And even if rape is a cognizable offense, you can write down all sexual offenses are cognizable offense. So you can remember MDR. And one, if you want to add two more, you can write down here, it is grievous hurt and even kidnapping. This is also important part of cognizable offense. Arrest without warrant. So these are the examples which are serious crime where police can arrest a person without warrant, cognizable. So the opposite definition is very simple. We have discussed cognizable offense, non-cognizable, arrest with warrant. Very simple, arrest with warrant. Example of cognizable offense are hurt, forgery. These are cognizable offense. Arrest with warrant, arrest with warrant. Non-cognizable, arrest without warrant, cognizable. The third definition is bailable offense. The bailable offense are those offenses where bail can be granted, and non-bailable offenses are those offenses where bail cannot be granted. So these are four other very, very important definitions: cognizable, non-cognizable, bailable, and non-bailable offenses. Very, very important. Now, sir, the next category we are coming to, if you see, this is compoundable or non-compoundable offenses. What is the meaning of compoundable? Any offense which can be settled, which can get agreement between two parties. Any offense which can be settled, which can be in agreement between two parties. And example of compoundable offense are defamation case or hurt case. That's a simple hurt case that can be settled outside the court. That is compoundable. But sir, the non-compoundable, which cannot be settled, no agreement, no settlement between parties. Definitely these are serious crime. And the example of non-compoundable offenses are rape, murder, or kidnapping. Compoundable, which can be settled, which can get agreement. Non-compoundable, which cannot be settled. So this is another very, very important category. You have to remember this also. So sir, we are coming to now a very, very important word. What are the types of court in India? What are the types of court in India? Yes, these are the court. I am writing down: number 1, Supreme Court; number 2, High Court; number 3, Session Court; number 4, Additional Session Court. Everyone knows that Supreme Court is the biggest court of country. High Court is the biggest court of the state. Session Court is the biggest court of district, that is Session Court. And in the same manner, the district also has Additional Session Court. So both are district court, session and additional session. Now we can say naam bada to kaam bada. So these are the 4 court, my dear friend. These are the 4 court. What are these 4 courts? Supreme Court, High Court, Session Court, or Additional Session Court. These are the 4 court which can give you death sentence and unlimited fine. These are the 4 court which can give you death sentence or unlimited fine. And actually, these are the higher court. I'm going to discuss the lower court also, but first I'll discuss higher court, Supreme Court, High Court, Session Court, Additional Session Court. And also, if you are confused between additional session and assistant session punishment, just see, additional has D and S. Very simple trick, unforgettable trick. Additional session court has D and S. That's the maximum punishment is given, death sentence or unlimited fine. So these are the 4 court which can give you death sentence or unlimited fine. Supreme, High, Session, Additional Session. Now, sir, done. We are coming to the court number 5, court number 6, court number 7 and court number 8. What are these 5, 6, 7, 8? Assistant Session Court, the number 5, yes. Additional I already discussed, death sentence is the maximum. CJM, what is CJM? Chief Judicial Magistrate. CJM, first class JM, first class Judicial Magistrate, and second class JM, second class Judicial Magistrate. CJM. Now, sir, in Metro City, we don't use word CJM, we use word CMM, first class MM, and second class MM. Now you must be thinking, sir, what is the meaning of MM? Metropolitan Magistrate. Metropolitan Magistrate. So in Metro City, we don't use word CJM, we use the word CMM, Chief Metropolitan Magistrate, first class Metropolitan Magistrate, second class Metropolitan Magistrate. Now we are coming to the punishment. I discussed these 4 give you the maximum punishment, but sir, these are lower court. What are the punishment given by this court? 10 year, 7 year, 3 year, 1 year. 10, 7, 3, 1. And what about the fine? Just remember the lower 2 fine. That is, second class gives you 5,000 rupees fine and first class give you 10,000 rupees fine. All remaining are unlimited fine. So that is a very simple trick. You can remember the different punishment of the court: Supreme Court, High Court, Session Court, Additional Session Court. Death sentence, unlimited fine. Done, sir. Assistant Session Court, CJM or CMM, first class JM or first class MM, second class JM or second class MM, 10, 7, 3, 1. What about the punishment? Just remember the lower 2. Second class 5,000, first class 10,000, all remaining unlimited fine. So these are the different court in India. Now, sir, juvenile. First you have to remember, what is juvenile? Juvenile is a child below 18 years of age. And who is the magistrate of juvenile court? The magistrate of juvenile court rank is first class JM. First class JM. Fast track court is of ranking of session court. So friends, listen very, very carefully. The juvenile is a child below 18. The magistrate of juvenile court is first class JM category. Yes, my dear friend. And fast track court is the category of the session court. Category of the session court. So these are the different court in India, the types of court, different punishment of court, and who is the presiding officer of juvenile court, which category, which ranking, session court, fast track court, which category. Fast track court, where the speed is fast, it's a session court category. So now I am coming to the commutation of death sentence. Who can change the death sentence? Commutation means you can remember by who can change the death sentence. First, I am telling you, the first death sentence is given by either session court or additional session court. So here I have written additional session court or session court. These are the court. Generally, these courts start with the death sentence because these are the lowermost court which gives the death sentence. Now, whenever additional session court and session court has given you death sentence, this death sentence is confirmed by High Court. This death sentence is confirmed by High Court. So if you get a question, who confirms the death sentence? High Court. High Court changed the death sentence, so commutation can be done by High Court also. Now, if High Court confirms, this is appealed. Very, very important, my dear friend. This is appealed. Appellate court is Supreme Court. So second commutation, second change can be done by Supreme Court. So this is appellate court is Supreme Court. He can change the death sentence. Now after Supreme Court, yes, my dear friend, the third power is President. If you see, the third power who can change the death sentence is President. This power is amnesty. What is the meaning of amnesty? President can forgive the death sentence. This power is known as amnesty. Dr. Sahab, don't worry. Here you can see the commutation of death sentence. The commutation or change in the death sentence can be done by three authority. Number one, High Court, who can confirms or who can change. Number two, Supreme Court, a appellate court confirms or changed. Number three, President confirms or change. So, Dr. Sahab, if you had a question, commutation of death sentence is done by, yes, number one, Supreme Court, number two, High Court, number three, President, number four, all. The answer will be all. All can change the death sentence. But if you want to pick one, the best answer will be President. If you want to pick one, the best answer will be President. So these are the four authority who can change the death sentence. All four are right answer, but if you want to pick one, the best answer will be President. Amnesty power. Appellate, Supreme Court, confirms the death sentence, High Court. Now, sir, I am coming to a very, very important topic. How to differentiate judicial magistrate from executive magistrate. So there are two types of magistrate, judicial and executive. As I told you, judicial is appointed by High Court. And executive is appointed by state government. So your government appoints you, that's executive magistrate, but High Court appoints you, that's a judicial magistrate. Now, so what judicial magistrate do? They go for trial in the court. And friends, judicial magistrate are superior if we compare with executive magistrate. So if you get a question, which magistrate is superior? The answer is judicial magistrate. And any police related death, like custodial death, police firing death, or any type of police related death, police beating death, custodial rape, in all these, the inquest is conducted by judicial magistrate. So judicial magistrate which is appointed by High Court. Now I am coming to executive magistrate. As I told you, these are appointed by state government. And Dr. Sahab, the function of executive magistrate is to maintain law and order in society, in country. They maintain law or order in society or country. That is executive magistrate. And friends, these are designated as DM or ADM, additional district magistrate or district magistrate. Designation is just like this. DM, ADM or even SDM. But sir, other government official can be appointed as an executive magistrate. The example is deputy collector. Yes, my dear friend. Tehsildar, deputy tehsildar, or RDO also. These all are appointed as executive magistrate. And my dear friend, executive magistrate conduct inquest in dowry death or exhumation. Executive magistrate conduct inquest in dowry death or exhumation. So this is the basic difference between judicial magistrate and executive magistrate. Very, very important question comes in exam. Now, sir, I am coming to a very important part. What is inquest in India? Sir, just pick the word that is inquest, I-N. It is investigation. It is investigation in COD. What is COD? COD is cause of death. COD is cause of death. So one thing is clear. Investigation in cause of death is inquest. So one thing is very simple. Inquest is done in death. Death cases, not in live people. It is done in death. So now, what are the two type of inquest in India? We are coming to number one is police inquest. Number two is magistrate inquest. If your investigating officer is police, it's a police inquest. If your investigating officer is magistrate, it's a magistrate inquest. Two type of inquest in India. So it depends who is your investigating officer. Now, Dr. because it's a procedure, investigation is a procedure. That's why it comes in BNSS. That's why it comes under BNSS. BNSS. And how to remember the BNSS of police inquest and magistrate inquest? Police marti hai chauka, magistrate marta hai chakka. That's a very simple trick. If you want to see the BNSS for police inquest is 194, for magistrate inquest is 196. 194 for police inquest, magistrate inquest is 196. So, investigating officer is police or magistrate. You have to remember one thing. In magistrate inquest, along with magistrate, police are also helper. Now we are coming to important part. Now, as I told you, your IO is either police or magistrate. If somewhere the crime has taken place, someone informed you, like there's a murder, the IO will go to the crime scene. And IO will take the help of the local witnesses who informed them. And my dear friend, these local witnesses are known as pancha. Panch. And friends, then the IO will examine the dead body if dead body is present there. Along with dead body, the IO will examine the crime scene. Because in crime scene there are many things, many evidences. What are the present in the crime scene? Dead body, evidences, traces of evidences, weapon, and they will take photograph of the dead body and the photograph of the crime scene. So everything will be elaborated. Weapon, they will take the photograph of the weapon, they will seal the weapon. All other evidences like blood stain, hair, semen, clothes, anything, fingerprint, and photograph of crime scene and dead body. And so after this, they will make a report. This report is known as inquest report. And my dear friend, this inquest report is known as Panchnama. So Panchnama will be done by IO after making a report. Everything will be assembled. Then, Dr. Saab, if the dead body is there, this IO will take this dead body for medico-legal autopsy to a doctor. This autopsy will be done by doctor. And now the question comes, after autopsy, the medico-legal autopsy is done, the dead body will be handed back to, give me the answer, relative or IO? This is a medico-legal autopsy. So this will be handed back to IO, investigating officer. So this is a very, very important part. Police inquest or magistrate inquest, whoever is IO, they will take the dead body to doctor for medico-legal autopsy. After autopsy done, the doctor hand this dead body back to the IO, over to IO, investigating officer. So as I told you, this is two type of invest we have. Number one, 194 BNSS police, 196 BNSS magistrate. Friends, the most common inquest in India is police inquest, because most of the time you see police is an investigating officer. And what is the minimum rank of police, my dear friend? The minimum rank of police is senior head constable. Not head constable, senior head constable. Apart from senior head constable, it can be the sub-inspector, inspector, or any other rank, CI, circle inspector. But the question comes, what is the minimum rank of police officer to conduct the inquest is senior head constable. And as I told you, it is most common, so it is done in all type of unnatural death. All types of unnatural deaths. And everyone knows what is the meaning of unnatural death. Any death which is not natural. Any death which is not natural. Example, suicide. Example, homicide. Example, accident. These all are unnatural death. So if you get a question, which is the most common inquest in India, that is a police inquest. And as I told you, this is 194 BNSS. Done, sir. Now I am coming to magistrate inquest. Magistrate inquest. As I told you, magistrate inquest is 196 BNSS. Magistrate Martha Chakka. So it is done in 6 death. Magistrate inquest is done 6 for 6 death. Yes, my dear. Magistrate inquest is done for 6 death. What are these 6 death? I have made a very simple trick. A, B, C, D, E, F. These are the 6 death. I'll start with A. Listen very, very carefully. If the death is in A for mental asylum. If the death is in mental asylum, magistrate conduct the inquest. Number 2 death is death in police beating. If police is beating, that is number 2 death. Number 3 death, C, custodial death, my dear friend. Or even if custodial rape, there is a magistrate inquest. Number 4 death is dowry death, or any married woman dies within 7 years of her marriage. A, mental asylum death. B, police beating death. C, custodial death or custodial rape. D, dowry death, or any married woman dies within 7 years of her marriage. It's very important. Even if it's a natural death, it will be a magistrate inquest within 7 years of her marriage. E, exhumation. Sir, what is exhumation? Exhumation is digging out of the dead body. Exhumation is digging out of the dead body from some place, from grave. And it's a lawful digging out of the dead body. That is exhumation, not illegal. It's a lawful. Presence of magistrate, doctor and police is there. And number 6 is death in police firing. Number 6 is death in police firing. And also you will see the death in police beating, the death which is custodial, and death due to police firing. These all 3 deaths are related with police. These all 3 deaths are related with police. So my dear friend, in all these 3 deaths, it is by judicial magistrate. My favorite MCQ. In all these 3 deaths, it is judicial magistrate. By police beating, by custodial death, custodial rape, or police firing death. In all remaining death, listen very, very carefully. In all remaining death, this inquest is done by executive magistrate. What are the all remaining death? Death in mental asylum, death in dowry death, married woman within 7 years, exhumation. And of this I discussed here also, you can see. This I discussed. Police related death, it's a judicial magistrate. All remaining death, it's a executive magistrate. This I discussed earlier also. So these are 2 inquest system in India. The most common is police. In 6 cases, it is magistrate. And how to remember? It is 196 BNSS. Because I told you 2 type of BNSS. 194 police Martha Chakka, magistrate Martha Chakka. 6 for it is 6 types of death, magistrate conduct the inquest. So 2 type of inquest in India, only police or magistrate. Now, inquest not present in India. Number 1, coroner. Number 2, medical examiner. Coroner inquest present till 1999, and it was only in one city, that was Mumbai. But now it is not present. Before Mumbai, it was in Kolkata. That's a different issue. But now coroner inquest is no more in India. Till 1999 it was there, and now it's abolished. Sir, this inquest system was based on jury system. But sir, if it is not present, no need to discuss this. It was based on jury system. Now the second which is not present in India, that is medical examiner system. It is in developed country like USA. And my dear friend, medical examiner inquest system is considered as the best inquest system for world. It is the best inquest system for world. Medical examiner inquest. Medical examiner system. So these are some very, very important points. What inquest system not present in India? Coroner and medical examiner inquest system. Now sir, listen very, very carefully. The next important part. We are coming to, the inquest is done, investigation in cause of death is done. We are coming to court procedure. And sir, these are the court procedure for taking evidences from witness. So I would say witness has to follow court procedure. And the first procedure the witness follow, that witness gets invitation card from court. Invitation card from the court. And my dear friend, this invitation card is known as summon. Summon is a procedure. Summon is a procedure, so it is a part of 63 से लेकर 71 BNSS. So courts send summon to witness. So I would say the summon is a document. Summon is a document, and my dear friend, on this document, date is given, time is given, and even the address of court is given. Date, like any date, 25 January, time 10 a.m. in the morning, and address, Saket Court, and whatever it is given, Patiala Court, it is given. You have to attend the summon. The reason is, sir, summon is also known as subpoena. Summon is also known as subpoena. What is the meaning of subpoena? Sub means under, and poena means penalty. What is the meaning of this? If you don't attend the summon, there will be some penalty. Sub means under, poena means penalty. If you don't attend the summon, there will be some penalty. And this penalty is under a BNS 208. 208 is a BNS. If you don't attend the summon, there will be penalty. 6-month imprisonment, 10,000 rupee fine, or more, or both. 208 is non-attendance of summon. If you don't attend the summon, 208 BNS would be applicable. Now, sir, I am categorizing summon in two categories. Number 1, number 2, A and B. What is the meaning of these two? Subpoena. Subpoena is summon. Ad testificandum. What is the meaning of this? Ad means attend. Testify means evidence. So, if you attend the court after summon and testify, what is the meaning of testify? The meaning of testify means giving evidence. If you attend the summon and testify in the court, this is very, very important. Attend the court and testify in the court, very, very important. Sir, this is for common witness. This is for common witness. Common witness attend the court and give evidence in the court and go. That is subpoena ad testificandum. Word is used for common witness. Now, sir, I am coming to subpoena duces tecum. What is the meaning of duces? Duces is document. Tecum means take. Which witness takes document along with him or her? Example, expert witness. Example, expert witness. Like I'm giving example, doctor. If doctor attends the court as the expert witness, doctor takes postmortem report or MLC with him. So this is a document. Postmortem report or MLC is a document which is taken by a doctor. So it is subpoena duces tecum, used for expert witness. Just remember two words, subpoena ad testificandum for common witness, and subpoena duces tecum is used for expert witness. Doctor takes document, this is duces tecum, and common witness goes and give evidence. It's a subpoena ad testificandum, attend and testify. Testify means evidence. Just remember that part. So this is summon. Now, sometime summon is subpoena under penalty. Sometime the question comes for the same date. Yes, you got two summon. For the same date, you got two summon. Same date, same time, you got two summon. One is from civil court, another is from criminal court. And I'm just telling you three sequences. If you got one from civil court, same date, and another from criminal court, the preference should be given to criminal court. This is the first situation. Civil, criminal, preference should be given to criminal. Now, sir, if both court are criminal, if both court are criminal, or you can say if both court are civil, what would you do? Sir, if both court are criminal or both court are civil, you will attend the higher court. If I'm giving example, you got summon from one from session court, another from high court, and both are criminal, you will attend high court because high court is higher than session. And even both are civil, just see the which is higher. Now the third situation, if both court are, listen very, very carefully, same level. If both court are same level, you just attend the summon which has been received first. You just attend the summon which has been received first. If both are of same level. So, Dr. Sahab, just see the sequence. Civil, criminal, sequence is criminal. Both criminal attend the higher court. Both same level attend the first received summon court. And Dr. Sahab, just remember, whatever court you are attending, attend that court, but whatever court you are not attending, send an application with the copy or photocopy of another court's summon. Send an application to another court which you are not attending with the photocopy of the summon of the court which you are attending. Application has to be sent. So if you are attending criminal court, send an application to civil court. If you are attending higher court, send an application to the lower court. And if you are attending the both same level court and attending the first received summon court, send the copy to another court. So just see this sequence while attending the summon. So the first procedure I discussed summon when you attend the court. But sir, the very, very important second procedure is oath. When you go to the court, you take oath. My dear friend, the age limit for oath, below 12 years of age, the oath is not required. Oath is not required below 12 years of age of a child. Not required. So what is the age limit of taking oath? 12 or above 12. Sir, if you refuse for the oath, it is punishable under 213 BNS. 213 BNS. There may be 6 month imprisonment or 1,000 rupee fine if you refuse for oath. Summon not attending 208. Oath, it is 213 BNS. Now, Dr. Saab, two situations. This is situation number A, this is situation number B. Mostly oath is taken on the name of God. Oath is taken on the name of God. Some books are there, holy books are there, Gita, Bible or Quran. You put your hand on these holy books and then you speak. After this, whatever I shall speak, truth, number one. Whole truth, number two. And nothing but the truth. So these are three statements. These are three statements. As you can see, whatever I shall speak, truth, whole truth, nothing but the truth. Truth, whatever you know. Whole truth, that should be complete, my dear friend. Incomplete truth is also just like a lie. That should be complete truth. And nothing but the truth. So these are three important components. Truth, whole truth, nothing but the truth, generally taken after swear on the name of God. But sir, the only exception is if you are atheist. If you are atheist. Atheist is a person who doesn't believe in God. Atheist is a person who doesn't believe in God. What atheist says, I solemnly affirm, and the same sequence. Yes, I shall speak truth, whole truth, nothing but the truth. So if you don't take the oath, refuse for oath, it's a 213 BNS. Now it's a BNS. Age limit for oath is 12 years. And how do you take oath? You swear on the name of God, I shall speak truth, whole truth, and nothing but the truth. But for atheist, what do you use? I do solemnly affirm, and the same sequence. Atheists do not take the name of God. So atheists, they do not take the name of God. They say, I do solemnly affirm that I shall speak truth, whole truth, and nothing but the truth. Okay, so this is how do we take oath. So first part was summon, second is oath, but now I am coming to the most important. Sir, even after taking oath, if you are giving false evidence, my dear friend, this false evidence is known as perjury. This false evidence is known as perjury. As you can see, perjury has 7 letters. So perjury is defined in 227 BNS. It's a definition of perjury. It is definition of perjury. So if you get a question, what is perjury? It's a false evidence. Which BNS for perjury? 227 definition. Sir, this is definition of perjury. The punishment of perjury. Punishment of perjury is 229. This is punishment of perjury up to 7 years. Up to 7 years. So definition of perjury 227, punishment of perjury 229. So how to remember perjury? 7 letter 227 and the punishment of perjury 229. Now sir, fabrication of false evidence. You just see FF, 2F. And everyone knows that F 6 letter, F 6 letter, 2F. 6 plus 6, it is 12. And if you see the BNS, 2 plus 2 plus 8, it is also 12. Fabrication. It's like you are putting some false evidence, you are taking away some evidence and putting some other evidence. This is fabrication. And it is 228. Now, so listen very, very carefully. Issuing false certificate 234. How to remember this? I am providing a very simple trick. Sir, actually, if you give right certificate, that is you are doing 1, 2, 3, everything right. And if you are making 1, 2, 3 in 2, 3, 4, that means you are making false certificate. Very simple trick. So it is 2, 3, 4 BNS. In place of 1, 2, 3, you are making 2, 3, 4. You are hiding or you are concealing 1. That is false certificate. 2, 3, 4 BNS. Disappearance of the evidence. Oh my dear friend. Actually, sir, if you see the disappearance, it is 13 letter. And if you calculate 2 plus 3 plus 8, 238, that is 13. So disappearance of the evidence, it is through 3-8 BNS. So again, I'm revising. Perjury, 7 letter, 2 to 7. Punishment of perjury, 2 to 9. Fabrication of false evidence, FF, 6 plus 6, that is 12, 2 to 8. False certificate, 1, 2, 3, you are putting 2, 3, 1 false certificate. End of sub. Disappearance of the evidence from crime scene, you are removing some evidences like blood stain, fingerprint. That will be, the sum will be 13. That is 2, 3, 8. Now, sir, summon done, oath done. Now I am coming to third procedure, examination of the witness. And my dear friend, examination we can classify 3 categories: chief examination, cross-examination and re-examination. What are the 3 examination? Chief examination, cross-examination, re-examination. Chief examination is the first one by same party lawyer. Cross-examination is by opposite party lawyer. And my dear friend, there is no time limit for cross-examination. And re-examination is again by same party lawyer. So first, chief examination is by same party lawyer. Second, cross-examination by opposite party lawyer. Then re-examination again by same party lawyer. But you can get a question, no time limit for cross-examination. It can take few days, few months also. So this is by lawyer examination. But when judge can ask question, judge or magistrate, at any point of time, judge or magistrate can ask question at any point of time. In chief, cross and re, in any point of time, judge or magistrate can ask question. So these are 3 examination in sequence. Judge and magistrate can ask question at any point of time. Now, sir, as I told you, chief examination is by same party lawyer. Cross-examination is by the opposite. So just see. First, I'll discuss chief examination. If you are a prosecution witness, who will chief examine you? And if you are a defense witness, who will chief examination? If you are a prosecution witness, listen very, very carefully. You will be chief examined by your same party, public prosecutor, prosecution witness, and public prosecutor, same party. And if you are a defense witness, you will be examined by defense lawyer because this is same party. So you can see prosecution witness and public prosecutor are of same party and defense witness and defense lawyer are from same party. As I told you, chief examination is by same party. Now cross-examination. If you are prosecution witness, cross-examination will be done by DL, defense counsel or defense lawyer. And if you are a defense witness, it will be done by public prosecutor. Re-examination again by same party. Prosecution witness, it will be public prosecutor. And defense witness, it will be defense lawyer. So just see what is the meaning of PP, public prosecutor, DL, defense lawyer. So if you are prosecution witness, chief examination and re-examination by same party lawyer, that's a public prosecutor. And cross-examination is by defense lawyer if you are a prosecution witness. But if you are a defense witness, cross-examination is by PP, public prosecutor. Remaining examination is by defense lawyer. So just see, this is the sequence of examination. First chief, then cross, then re. Remember, public prosecutor and prosecution witness are of same party. Defense lawyer and defense witness are of same party. Now, Sir, now the question comes, leading question. First of all, I would like to tell you, what is the meaning of leading question? Leading question is a question which has answer in yes or no. Leading question is a question which has answer in yes or no. Like example, the example of leading question was Ram wearing white shirt. Was Ram wearing white shirt? This is an example of leading question because this question has answer in yes or no. Now the question comes that leading question are permitted in cross-examination. Leading question are permitted in cross-examination. This is situation number 1. But sir, the situation number 2, when your witness has become hostile. What is the meaning of hostile witness? The witness which is not desirous of telling truth. The witness which is not desirous of telling truth, that is a hostile witness. He is changing the statement, that is a hostile witness. The witness who is changing the statement, who is not desirous to tell the truth, that is hostile witness. Hostile witness is a condition because now your witness is changing the statement. Your witness is not telling truth. That is not good for you. So hostile witness is the only condition in which in chief examination, the same party lawyer can ask leading question because your witness is not desirous of telling truth. So you can take the permission from judge. Sir, please grant me permission to ask leading question to my witness as well because my witness has become hostile. So only condition where leading question are allowed in the chief examination, that is that your witness has become hostile. Your witness has become hostile. Here in chief examination, leading questions are allowed. So my dear friend, examination is also done. Summon done, oath done, examination done, chief cross redone. Now I am coming to the sequence number 4. Sequence number 4. So number 3 sequence I already discussed, examination. Now we are coming to sequence number 4, conduct money. Sir, what is conduct money? First of all, I would like to tell you, conduct money is a diet money. Conduct money is a diet money. This conduct money is paid to witness to meet his or her expenses. It is a diet money. Conduct money is a diet money. Conduct money is a diet money which is paid to the witness to meet his expenses, like traveling expenses, diet expenses. This is conduct money. Now, sir, there are 2 scenarios. Conduct money in civil case, conduct money is in criminal case. Sir, listen very, very carefully. In civil case, because I told you civil case is between 2 parties. So, conduct money in civil case is paid by party. In civil case, the conduct money is paid by party. Now, situation number 2. Generally in criminal case, conduct money is not paid. Generally, I'm talking about the general scenario. Generally, in criminal case, conduct money is not paid because it is our duty to reduce crime in India, and if we are asking money for that, we are not good Indian citizen. So generally, in criminal case, conduct money is not paid. But sir, I am coming to one exception. Yes. This exception is expert witness. If you are an expert witness in criminal case, the conduct money is paid. It is paid by court to expert witness. It is paid by court to the expert witness. So I am giving some very important scenario. In civil case, it is paid by party. In criminal case, generally it is not paid. But only exception is, yes. If you are an expert witness in criminal case, it is paid by court, government. So this is the 4th situation done, conduct money. First summon, second oath, third examination, fourth is conduct meeting. This is the sequence for a witness. Now, sir, actually, wherever you are making some report, you have to go for oral testimony. I'm giving you an example. Like you are a doctor. You are a doctor. You have made number 1 postmortem report and number 2 MLC, medical legal certificate. Doesn't matter. Now, sir, even with these 2 reports, you have to attend the court and there will be oral testimony. Oral evidence will be there for a doctor. But I'm going for some exception. I'm going for some exception where your document is valid as it is. This is you have to do in court. You are a doctor, along with postmortem report, along with MLC, you have to attend the court and you have to give oral testimony. But there are some exceptions in which the statement or the document or the written statement is considered as it is. The statement, written statement or document is considered as it is. No need to go for oral testimony. I'm coming to that exception. No need to go for oral testimony. What are these cases where no need to go for oral testimony? Only statement or record is taken as it is. Number 1 condition is dying declaration. Statement given by a dying person. If the person dies, the died person cannot come for the statement. So dying declaration is the first condition. Dying declaration is the first condition where oral testimony is not needed. So I am writing down this is first. Second condition, sir, any expert who has given the expert line in the textbook or treaty, like the expert line in the book is written, the cause of death is asphyxia due to hanging. If I take this line as it is in my postmortem report, the author won't come to prove this because that's a reference book. So that line or expert opinion given in textbook is considered as a document, valid document. No oral testimony needed by author. Number 3, doctor's evidence recorded in lower court. If doctor evidence is recorded in the lower court and the cases is appealed at higher court, no need to go doctor again in the higher court. So that evidence in the lower court will be considered as it is in higher court. No need to come doctor for again. Number 4 condition. Few reports, Dr. Sahab, this is I am highlighting again and again. Few reports, very, very important, sir. Few very, very important reports. Number 1, chemical examiner report. Number 2, chief inspector of explosive report. Number 3, serologist report. Listen very, very carefully. Chemical examiner report, chief inspector of explosive report and serologist report. Sir, these are 3 reports which are considered the document as it is as a evidence. No need to come these toxicological examiner, the chemical examiner, the serological examiner to the court. Number 5 condition. Evidence given by witness in previous judicial proceedings. Sir, if witness give evidence in previous judicial proceeding, that will be considered as it is in the next proceeding. Number 6, very, very important, public record and hospital record. Public record and hospital record. Doctor, these are the 7 exceptions of oral testimony. No oral evidence is required for these 7 conditions. Number 1, dying declaration. Number 2, any line written in the textbook, which is a reference book. Number 3, the doctor in lower court doesn't need to come in the higher court. Number 4, serologist, chemical examiner or explosive report. Number 5, previous judicial proceeding. Number 6, public record. Number 7, health record. These are considered as it is. As it is. Yes, my dear. Now, sir, I am coming to dying declaration or dying deposition. Dr. Sahib, it is a statement given by dying person. Dr. Sahib, dying declaration first I'll discuss, that is in India. And a very simple trick, D is the 4th letter. D is the 4th letter. 4 plus 4, 8. And 2 plus 6 is 8. So, Dr. Sahib, very simple trick. Dying declaration is 26 BSA. dying declaration is 26 BSA, Bharatiya Sakshi Adhiniyam. Dr. Sahab, if you are dying and you want to give statement, this statement can be oral or written statement. It can be recorded, it can be written. My dear friend, the doctor will examine that person is compos mentis or not. What is the meaning of compos mentis? Sound mind. The meaning of compos mentis is sound mind. So, doctor will examine the compos mentis. Now, who records this dying declaration? First priority, victim himself can record. Second priority, magistrate. Third, doctor. Fourth, police. Fifth, any public. So the best is if the victim records or if there is a presence of magistrate, but it can be taken by anyone. Now, sir, this recording is mostly done in the presence of two witnesses. But sir, we presume in India that dying person never lies. So, Dr. Saab, we don't take oath, we don't go for cross-examination, we don't take leading questions in dying declaration. Now, sir, three important situations. Number one, if your statement is incomplete, still it would be valid. If like suddenly you died after telling the incomplete statement, it would be valid. So incomplete statement is also valid. Second, if you survive after dying declaration, it is invalid, because if you survive, my dear friend, if you survive, that means you have to give oral testimony in the court, oral evidence. So if you die, then it's a valid. If you survive, it's not valid, invalid. And if you are not in compos mentis, it is also invalid. So I have given three important conclusions. Number one, incomplete dying declaration is also valid. Number two, if you survive, it is invalid. You have to come for oral evidence. And if you are not in compos mentis, you are not in sound mind, if doctor declares you unsound mind, it is not valid. So this is a very, very important part, dying declaration, 26 BSA. Oath is not taken, cross-examination not done, leading question are not asked. It should be in compos mentis. And this is statement given by a dying person, dying declaration. But sir, in developed country, they have dying deposition. Like in USA, they don't have dying declaration. They have dying deposition. So it is in developed country. And my dear friend, it is only and only by judge and magistrate, not by other person, not any other person. And it is in the presence of accused or defense lawyer. It is in the presence of accused or defense lawyer. Look, sir, what are the three special things of this? It is just like a court. Oath is taken, cross-examination is done, and leading questions are also being asked. So one thing is clear, it is superior if we compare with dying declaration. And the best part is cross-examination. The best part of dying deposition is cross-examination, because by cross-examination, you can protect the accused. All are best part. Magistrate, best part. Accused and defense lawyer is also there, very good part. Oath is taken, very good part. Cross-examination is done, another good part. Leading question are asked, another good part. But if you want to pick between all these, the best is cross-examination. Because by cross-examination, if you are telling lie, you can protect the accused by cross-examination. That's why if you get a question, which is superior, dying declaration or dying deposition, the answer will be dying deposition. Dying deposition. So just see this very, very important part. Now, sir, one very common question generally being asked in your exam, what is the age limit of giving evidence or testify in court? What is the age limit of giving evidence or testify in court? Just remember, my dear friend, no age limit. No age limit for giving evidence and testify in court. insane person and intoxicated person. Insane person and intoxicated person, their evidence is never valid, invalid. Insane and intoxicated. Insane and intoxicated, their evidence is never valid. And sir, even if you are a dumb witness, you can give evidence by writing or by signing. So again, I'm telling you few important points. The first point is there is no age limit of giving evidence. If you are insane or intoxicated, your evidence is invalid. And dumb witness can give evidence by writing or by signing. Three important components of giving evidence in the court. Now I am coming to MCQ part of this very important chapter. Yes. Sir, the first question is very simple. That is, who is responsible to handling for the investigation in custodial death? I told you two inquest. Police or magistrate. Very simple. In custodial death, it is judicial magistrate. All police related death. Police beating, police firing, custodial death, custodial rape, it's a judicial magistrate. All remaining death like mental asylum death, dowry death, exhumation, it is executive magistrate. Sir, 196 BNSS, 194, 196. 194 police मारती है चौका, magistrate मारता छक्का. So 196 BNSS is magistrate inquest. 194 BNSS is police inquest. Power of first class judicial magistrate. Yes, I told you three magistrate: chief judicial, first class judicial, second class. And I told you 7 year, 3 year, 1 year. Chief, first class, second class. And the fine, the lowermost is the fine 5,000, 10,000 and unlimited fine. So I told you these three magistrate: chief judicial, first class and second class. This is chief, this is first class, this is second class. So you can see 3 year imprisonment with 10,000 rupee fine. That is for first class. That's okay. Now, the dying deposition carries more weightage than dying declaration. What is the reason, sir? I told you many reasons. Yes, it is taken on the oath. It's very good. It is cross-examined by defense lawyer. It's very good. Statement recorded by magistrate. It's very good. So here answer will be all of the above. But sir, if the word is given, what is the best reason? What is the best reason? Then your answer will be B. But here, they didn't ask about the best reason. The answer is all of the above. But best answer, if the best answer is being asked, the answer would be B. Done, sir? Sir, if witness is declared hostile. Now, Dr. Sir, normally, leading question are allowed in the cross-examination. But if witness is hostile, leading question are also allowed in chief examination. I told you this one. Chief examination. Who can commute a death sentence? All, like High Court, Supreme Court or President. But again, if the best answer is there, they ask the best, the answer will be President. But they didn't ask the best, the all is the right answer. Death sentence can be awarded by, sir, first class, no. Chief Judicial, no. Assistant Session, no. But I already told you the trick also. Additional ADS death sentence. Death sentence can be awarded by additional session court. Cross-examination of defense witness. Chief examinations by same party lawyer. Cross-examinations by same party lawyer or opposite party lawyer. It is opposite. So defense witness, opposite party is public prosecutor. Public witness, the opposite party is defense lawyer. But here, the question is about defense witness, opposite party is public prosecutor. Dr. Saab, perjury is punishable. Dr. Saab, they asked the perjury definition. Perjury is 7 letter. 227, that's the definition. But they asked about the punishment. Perjury punishment is 229 BNS. 229 BNS. Perjury punishment. Sir, false certificate. Dr. Saab, if you issue 1, 2, 3, it's a true certificate. 1, 2, 3, 2 certificate. 2, 3, 4, it's a false certificate. It's a 2, 3, 4 BNS. It is not IPC, it is BNS. Yes. 2, 3, 4 BNS. Ho, my dear friend, this is all about a very, very important chapter. Court of law, we have discussed everything important for court of law. Just go and revise these notes. These are very important, tricky notes with high mnemonics. Good luck. Goodbye.